Mr. Ribble, I don't know if you both have been as cold as we have been up here. Is it all right down there?
It was initially quite warm, and then suddenly it became very cold midway through the morning.
Well, I'm afraid I'm sheltering under a blanket. So
That's Wednesdays in this building. It starts out hot and goes cold.
Last time I was over here, I overheated. So
well, if anybody wants to wear a coat or anything else, a hat, they would be. I don't think any of us will take any offence.
Well, in one sense, we
wearing
already
hats.
are.
Anyway, thank you, yes.
Milady, before the luncheon adjournment, I think I got as far as criticising the decision or the assessment of His Honour Judge Owen in relation to whether or not District Judge Nicolle at first instance struck out the proceedings on the grounds of abuse. There was just one more point I was going to make, and I suppose to a certain extent it's a broader point, which is, and this links back to the earlier submissions I made on 4415, that what is required, I say, for the gateways under 4415 to be satisfied when one is looking at abuse as an example, but also circumstances where there is conduct obstructing the just disposal of the proceedings, is a judicial assessment of whether there has been that conduct and whether the proceedings should therefore be struck out in consequence of that conduct. And I think it must be right to say that plainly that assessment was not carried out by District Judge Nicolle. So insofar as there was a strikeout allied to abuse, it was not the sort of strikeout for abuse that is envisaged by 4415. I'll move on then to the appeal, and I hope as part of this I'll answer some of the questions that were asked of my learned friend in terms of how this or the abuse arguments were put below. Can I go to the supplemental bundle, please, and page 59, which is part of the respondent's notice that was put in response to the appeal.
Sorry, core bundle 59.
Supplemental bundle 59.
Yep.
So these are the respondent's reasons for upholding the decision of DJ Nicolle pursuant to CPR 52.13. I just want to start at paragraph 3 if I can. And it's the first and second sentences. So the first sentence, at the hearing of the substantive application, the judge determined that the claim form was out of time. She made a declaration that the court would not exercise its jurisdiction and therefore the claim would be struck out. So that was the defendant appellate's or defendant respondents at that point understanding of the basis of the strikeout at that point in time. It's a strikeout on procedural grounds. The judge also found the conduct of the claim amounted to an abuse of process. So again, in terms of how the defendant understood the position at that point in time, if that understanding is correct, then plainly the decision of the district judge at first instance was wrong because the causative element is missing. Can I then ask you to turn to page 61.
My fault, I'm not following. What are you saying?
So I'm saying that for the automatic exceptions for quotes to be disapplied.
But struck out on the ground of abuse.
Yes, and based on the defendant's own summary of the decision made by the district judge, that is not what the district judge had done. The defendant's own summary was that she had struck out for procedural reasons and then gone on to make a finding of abuse.
Fine. So, yes, you're focusing on the word found.
Yes. Yeah. So she might have found abuse, but what she didn't do is say, I found abuse, therefore I'm going to consider whether to strike out, and I'm...
We need to be realistic. I mean, the hearing was one single hearing, and the order wasn't drawn up, and then somebody came back and argued abuse separately. It was at the same hearing in the same context. I do understand the point that you make about the strikeout for abuse being limited to procedural failure.
Yes.
But I'm not quite sure that it's right to sort of divide. Clearly, she did first strike out, but she did say she would have struck out before the order was drawn up and sealed and all the rest of it, didn't she?
I'm not sure she goes as far as saying she would have struck out, but even if she does go that far and say she would have struck out, that of itself is not enough because that's not the causative reason.
Okay.
Can we go on, please, to page 62
Yes.
Of the supplemental bundle? Sorry, I don't mean page 60, so I wanted 61 first of all, which is response to ground 4.
Yes.
And so it's the response to ground 4 that runs the, if I can call this the pre-action abuse argument for the first time, and then it's paragraph 16 on page 62. So the way in which it's put initially in this document which accompanies the respondent's notice is in relation to the anonymisation as opposed to the choice of protocols. And I accept that's been a feature throughout the appeals, and that's the point I need to deal with. But it's not put on the basis of cherry picking. Can I then ask you to turn to page 76? Which is my learned friend's skeleton from below. Sorry, this is back in the core bundle, page 76.
Yes.
So the skeleton begins at 72, and then if I can ask you to turn to page 82. My learned friend below set out the test in cable at para 23, and then he made what at that point in time was the pre-action protocol argument, and it's the second sentence of paragraph 24 onwards. The pre-action letter of claim must comply with the pre-action protocol for media and communication claims as set out in the White Book. So the argument advanced in writing prior to the hearing below was
That
not...
it should have been personal injury protocol, but that it was just a meaningless correspondence.
Yes.
Yeah.
I accept it's a development of the point trailed previously, which is that there's anonymisation, but it's not that you chose the wrong protocol. That then brings me to the judgment itself, which does reflect how matters were argued orally. And can I ask you to turn to page 64 of the core bundle? And it's paras 82 to 84, which I think are the best record of the way in which the matter was discussed below. And I accept a criticism was made below that these claims were advanced under the Media and Communication Claims Pre-Action Protocol as opposed to the PI protocol. Now, I'll make the slightly jury point if I can. If you've complained in your skeleton argument that there's a failure to comply with the Media and Communications Claim Protocol because that is the relevant protocol, it's a bit of an about turn, and it's hard to criticise the judge if the judge says that complying with that protocol that previously the defendant was saying was the right protocol is an abuse of process. But also it's important to note the extent to which the argument was being run, and the argument being run below was no more complicated than these are personal injury claims, therefore they should have been put under the PI protocol. There were not specific arguments advanced along the lines of there was a deliberate decision not to provide us with these types of information that would have been provided under the PI protocol, and that's why you chose one protocol, not the other protocol. It was put in this broad sense, and one of the reasons that the judge rejected that argument, we can see from the second sentence of paragraph 84, is because a criticism was made below that the letters of claim did not advance a claim for personal injury, and the judge found that to be incorrect.
Sorry, found that to be?
To be incorrect. He found that they did advance a claim for personal injury. That's the second sentence of paragraph 84. So in circumstances where the cause of action being alleged, and this is a repeating theme, the cause of action alleged is a data breach claim, and the loss of personal injury is identified in the letters, in our submission, the judge is entirely right to take the view there is no abuse in putting forward the letters on the basis upon which they are put forwards.
You may have done this before the short adjournment, and I'm sorry if this is right, but I remember Mr. Waite saying that you had 3 or 4 months to respond to why you wrote the protocol letters in the way that you did. Did you take us to the and he referred to a witness statement from his solicitor. Have you dealt with that?
Well, I have and I haven't dealt with it. I've dealt with it insofar as, and in fact, maybe the thing to do is to go to his instructing solicitor's statement and look to what extent
Yes, please.
the conduct is put in
And
issue.
apologies if you've already done this.
Well, I've dealt with it insofar as in my submission, there's no abuse argument run. We're not on notice that there's anything we need to deal
Right,
with.
just show me those paragraphs, please.
So it's the witness statement beginning at page 255
Of the supplemental.
of the supplemental bundle. And the extent to which our pre-action conduct is put in issue by, and this is the reply evidence, so the application goes in with evidence, we respond. So under the rules, in any event, this is the final shot on the evidence, and it's supposed to be responding to ours, not opening anything new up. But the criticism is put.
That's right. So we looked at this before. 258. Is that right? Paragraphs
Yes.
10, 11, and 12. Sorry. Yes.
Yeah.
Just give me. Would you mind if I just reminded myself once more what they said? Right.
So the complaint that's put is a complaint about redaction, and that complaint was put apropos of, and this is why I started with the statement in support of the application, that criticism is put apropos of an argument that the defendant had suffered prejudice as a result of being unable to investigate the claim due to a lack of detail being provided.
Thank you very much.
Picking up where I was then, the reason, of course, we raise these complaints is because we say that His Honour Judge Owen was effectively wrong to entertain argument on any of these points because they weren't raised at first instance. In fact, even further, I suppose, a further criticism we might have made of the district judge is that she shouldn't have adhered to the Quox argument at all when that wasn't the basis of the strikeout. My learned friend's primary response to that is to say that I'm seeking to cross-appeal by the back door. The answer to that comes from the Brace Yourself case, which is in the authorities bundle at tab 9. And I'd simply ask your lordships to read paragraph 31, which is on page 150 in your own time.
The point is you're seeking to uphold the order
Yes.
rather than anything else.
It is a legal impossibility for us to appeal because there is no order against which we could appeal. That is why the rules might appear to be more generous to us. It's because there is no attack that we are actually able to mount for exactly the reasons your lordship gives. So that's why we say we can raise these arguments. In terms of whether or not His Honour Judge Owen was right to permit these arguments to be advanced below, we say there are several clear errors of principle or failures to take relevant matters into account when he reaches this decision, and that's a decision that he reaches at paragraphs 77 and 78 in his judgment, which is on page 63 of the core bundle. If it assists, I accept that he correctly identifies the law, he correctly summarises the law. It's simply an application point. So we say point number one, his assessment of District Judge Nicolle's order is wrong insofar as she strikes out or appears to have struck out on the basis of procedural default, not abuse. Secondly, he fails to identify and consider the way in which the claimant's conduct of the litigation might have differed had this point been taken before. The obvious point being that if the claimant, or claimants by this point, plural, had known there was a risk to Quox protection, it would have been open to them to simply concede the application that the particulars are set aside. And had they conceded to that application, then Quox would have applied. He also failed to identify, and we say this is a relevant factor, the public interest. And we say there is an enhanced need for notice of this sort of application being advanced because of its significant impact. And insofar as he reached the conclusion, well, there was evidence about the parties' pre-action conduct, I accept the pre-action correspondence was in evidence, but what the judge failed to do was to ask himself, to what end was that correspondence in issue? And more importantly, to what extent had the claimant's solicitors been given notice of the need to explain why they adopted the approach that they did? And in my submission, there is a big difference between a prejudice argument and wanting to deal with a prejudice argument, to which in any event there was a straightforward answer, and that straightforward answer is the only party that suffers prejudice is the claimant, because the deceased's untimely death ultimately impinges upon her ability to bring the claim. That is, without wanting to be crude about it, something that benefits the defendant. There is a distinction between that and understanding that you are being criticised for litigation decisions that have been made vis conduct, and that unless you explain those, you're facing a risk of strikeout and you're facing the risk of quox. So we say that those matters were not sufficiently identified, and to a certain extent, I pray and aid the repeated submissions my learned friend made this morning when he said there's no evidence of why this protocol was followed, there was no evidence of why this was done, to which we say, well, the obvious inference is that that is because these points were not put below in the way they're being put now.
But did you submit before His Honour Judge Owen that you would want to put in more evidence if this was going to be run?
Yes.
On the
Pre-action conduct, yes.
And where do we see that?
I don't know that we do see that. We see a recording in the at paragraph 73 where the judge says the appellate say this is the end of the story and I should stop there. But there is...
I don't quite understand that. I thought your point was that I'm not doubting that you made the submission, but as I understand it, what you're saying is the point that was being put against you at that stage was about anonymisation.
Well, the point put in writing was about anonymisation.
We can see from paragraph 75, by the time we get to the judgment, the respondent says this was an attempt to ride two horses at the same time. So, no, but you're right, if I may say so, on what we've been shown on paper.
Yes.
But we can see that things developed. And effectively, let's call it, tactical games were being alleged.
Yes.
By the time we get to the hearing. Where do we see the submission by you in the context of this point being able to be raised, that you will be prejudiced because you would want the opportunity to explain the decisions taken in the your pre-action correspondence?
I do not think that the arguments on this point are fully reflected in the judgment. I can only refer you, first of all, to paragraph 73, where the fact that we dispute the judge's ability to consider these issues is raised.
That doesn't answer the point. It's really...
and then we also see at paragraph...
paragraph 77, it doesn't record, but of course this was an oral judgment, he doesn't record your a ground of opposition, if there was one, based on prejudice arising out of a lack of evidence on your side.
No, I have to accept that. I suppose I'd simply ask the court to draw the inference from 73 that we weren't saying the court should stop there, full stop, and offering no explanation for it, that we were offering submissions in support of the position adopted at paragraph 73. It's simply that because this is an oral judgment, it's not all captured in the judgment.
And so there's nothing in your skeleton argument saying this shouldn't be allowed because of prejudice. Where do we find your skeleton argument?
I don't think my skeleton argument from below is... I think that came through later.
Where do we see your skeleton below, in front of His Honour Judge Owen?
If I could assist the court, we emailed the skeleton, it was missing.
Right.
So I have hard copies for the court.
I have it in the updated supplemental bundle right at the end.
Right, if I could just
Item
be handed
38.
a copy. Thank you very much.
It should start from page 327 in the supplemental bundle.
I've got it electronically, so...
I thought we were being told that by the time you put the skeleton argument in, you didn't know this one was going to be run because it was only run orally. But,
Yes, certainly in terms of the picking between the protocols. I think also in terms of the skeleton argument, this skeleton argument was a skeleton argument that was prepared with the application for permission to appeal. So it's prepared before we get the document setting out the additional grounds for upholding the order. So we didn't, at the point in time when this document is drafted, which is dated June of 23, I think it's updated cross-references for the bundle, we didn't know that these points were going to be run.
Your recollection is that you made this point orally?
Yes.
And did you have a solicitor behind you at this hearing?
No, I did not.
It's a bit of a mess, isn't it? What's the? Remind me. Do we have? What are we talking about in terms of costs here?
I think it's probably cost of this appeal.
Yeah. What are the costs of this appeal?
Cost of this appeal are probably in the region of 100,000 between the two parties.
Yeah. And before His Honour Judge Owen?
I think we were awarded 10,000 on summary assessment.
Anyway, thank you. Okay.
So picking up where I was, so we say that these points, the judge didn't have permitted argument on them. That is as far as I wanted to go under what I think was my second head, which was how the case was run by the defendant below. That brings me on to my third head of submissions, which is cherry picking, which I'll try and move through quite quickly, because I think I've already given the headline, which is that the fundamental problem with the cherry picking argument is that we are not in an either-or situation. We have two sets of rules here. And I should say this is true both of the substantive rules and actually how the pre-action protocols are drafted. Quox rules and the PI pre-action protocol, it is the head of damage or loss that is the triggering factor. The rules in relation to success fees, ATE premiums, and also the application of the media and communications pre-action protocol when that comes into force, that is determined by the cause of action. And what we have in this case is a claim that sits at the intersection between those two. And this is where actually, to describe it as a deliberate decision to frame the claims in this way, it is an odd description insofar as they are data breach claims. The loss alleged is personal injury. That is the cause of action. That is the loss. Unless it's being said that a claim for the misuse of private information should not have been put forwards, and there was no application for that claim to be struck out on the basis it was unsustainable, necessarily by advancing the cause of action and the loss, you put yourself in that position as between the two sets of cost rules. And of course, we would submit that in terms of whether there's an abuse, or rather in terms of what costs are recoverable, it's the cost rules, not the pre-action protocol, which is the governing factor. And as I say, the pre-action protocol is clear. The other point I would make is that this appeal was advanced on the basis that these are presented pre-issue as data breach claims, and then post-issue a PI claim is suddenly tacked on. Well, we say that is simply incorrect, because a PI claim is set out pre-issue. My learned friend took you to one of the letters of claim that was sent, the letter of claim that was sent in October. There was also a February 2019 letter of claim, and that's at page 194 of the supplemental bundle, with the relevant extract at page 197 of the bundle, setting out that a claim for personal injury would be advanced. So it's not simply that there is a single mention pre-issue. There are two substantive letters of claim, anonymised I accept, and I'll come on to that in a second, but both of them make clear pre-issue that a claim for personal injury is going to be advanced.
Well, is that right? Can you just, I was taken, wasn't I, by the however paragraph. What are we to make of that? Page 198. However, in the event that we consider, and it is odd wording, isn't it? We're instructed to pursue And so on page 198, under the heading funding,
In relation to funding, I suppose one has to ask the question, when one is reading the letter, which passage of the letter does one understand to be setting out the losses claimed? Is it the section entitled injury and distress, or is it the section entitled funding? I accept that the paragraph in the section entitled funding is unhappily worded, but anyone reading that letter is going to look at the section headed injury and distress and use that as the basis for determining whether or not a personal injury claim is being advanced. In any event, it certainly can't be said that there's no hint of a personal injury claim and it just appears out of the woodwork later on. Clearly, at the very least, the possibility of such a claim is posited by those letters.
On the evidence we've been looking at, this letter was between the visit to the GP and the production of the report.
Yes. Of course,
It was the way things actually happened, whether or not that was compliant with the PI protocol, is that a threat to bring a claim for personal injury was made, a report was obtained, and then the proceedings were issued.
That is correct. I suppose in terms of the chronology of events, the solicitors, of course, cannot advance the personal injury claim purely off the GP's report. The fact that the claimant has been to the GP gives you the starting point that there is likely to be a claim for personal injury. They can't give full details until they've got the medical report, and that doesn't come until 2020. I was going to come on to this, but I suppose I'll make the point now that by the time that report is obtained in 2020, there have been multiple attempts at securing engagement with the defendant. I accept there's a criticism of how that has gone about, but there have been multiple attempts at securing engagement with the defendant. None have been successful. And so I suppose I asked the hypothetical question, what purpose would it have served sending another letter at that point in time when two clear letters of claim have been provided and neither of them have been engaged with in any meaningful way? The other point I wanted to deal with on cherry picking, I don't know that I necessarily need to, but just so I'm clearly set out our position, it's not simply that the rules permit someone to recover a success fee and have the benefit of quocs, that actually that is logically consistent because quocs and recoverable success fees are not two sides of one coin. Quocs were introduced to compensate for the removal of the recoverability of ATE premiums in PI cases. So they were to do with protecting claimants from adverse costs as opposed to helping claimants fund their own solicitors. The quid pro quo for the abolition of success fees was the increase in general damages. So there's no inherent tension there. The better point against me from a learned friend would be, but you reserved your ability to recover an ATE premium. To which I say, first of all, we reserved our right, but there never was an ATE premium that we sought recovery of in this case. The second point is, this was always potentially a mixed claim. And I say it was always potentially a mixed claim because that was my learned friend's submission at first instance, that if he was wrong on quocs, it was a mixed claim. Insofar as this was a mixed claim, and part of the claim for the misuse of private information is not a PI claim, quocs protection was not available. And so under the rules, it was perfectly permissible to protect that adverse cost exposure by way of an ATE policy and to recover that cost from the other side. Now, it may be said, well, what about if you take out an ATE policy that also covers you for a PI claim? To which the answer is, well, any mischief there is dealt with on detailed or summary assessment. Because of quocs, it would have been unreasonable to incur the cost of an ATE premium that gave adverse cost funding in a personal injury claim, so it would have been irrecoverable to that extent. So the mischief upon which the appeal is based simply does not exist. The final point I suppose to make is that it was, of course, a deliberate policy decision to exempt certain types of media and communications claims from the Jackson reforms. That was done, as I understand it, in the wake of the Leveson reforms. It was deemed that certain types of claims should be facilitated until that was challenged later on and the government change the law in relation to access to justice concerns in the opposite direction. But we say that the riding the two horses argument, whether one looks at the law, the policy underpinning the law, or the pre-action protocols, is simply a bad point. That then brings me to the presentation of the claim and the way in which it's put forward pre-issue. And I suppose whether or not the judge was right, first of all, to find that was not an abusive process, and secondly, even if this court finds that that is wrong, whether it would disturb the judge's discretionary decision that any abuse would not have been sufficient to strike out the proceedings. Can I adopt as the starting point, and I've partly taken this summary from a learned friend's skeleton argument, that the nature of the claim is that the claimant has a past criminal record revealed to a friend when they contact the defendant. And the background to that contact is that the claimant is a self-employed carer and the defendant is an agency that effectively places carers with vulnerable individuals. So the basis of the claim is that people have found out about a past criminal record. It's obviously something that causes distress, we would say, but also one of the complaints in this case is that, or rather the reason the defendant provides this information is because the defendant says that the past criminal record means it will not offer employment to the claimant. So this is necessarily the sort of information that the claimant wants to keep confidential insofar as she is able to. And I would invite you to infer from the way in which the letters are put forwards, and I have to do this by way of inference because I don't have a witness statement from my instructing solicitor saying the reason we did this is that. For the reasons I've given, we weren't given notice. But I will invite you to infer that the reason for the anonymisation stems from the nature of the complaint and the claimant's desire to prevent, insofar as possible, any wider dissemination of her past criminal record. That is why, for example, if I can ask you to turn to page 192 in the supplemental bundle. So 192 is the pre-letter of claim notice that is sent out. Now, there are some identifying factors. The claimant's actual initials of RT are used. There's reference having written direct to the claims. I think your ladyship asked about that earlier, and a breach date is given. And then the letter goes on, the claimant is extremely sensitive about the release of their personal details and would therefore request you supply us with an email address for a suitable officer or employee to which we may securely email an encrypted version of the letter of claim in due course. And then if I can ask you to turn to page 229 in the same bundle.
It's very difficult to understand, isn't it, what's going on here? I mean, the proceedings were then issued unanonymised, and you're writing to somebody who knows exactly who you are on this basis.
Well, I suppose it's difficult to know. We think, or I ask you to infer based on that letter, that the claimant expects the defendant will put two and two together. But what the claimant is trying to do, by reference to the secure email address and sending an encrypted letter of claim, is to set up a secure method of communication between her solicitors and the defendant, because there is reluctance to send a letter of claim which could be picked up by anyone, containing details of the claimant's identity, and importantly, it would have to be details of the claimant's criminal record. And for the reasons I've given, whether it's personal embarrassment or actually because she works in the care field, this is a significant employer in the care field, people who work for this employer may end up working for other employers, there is an understandable desire for confidentiality. Now, it may be that that is the wrong decision, but this was effectively the thrust of His Honour Judge Owen's decision below. He did not agree with that decision. That decision was a mistake. The letters were sent on purpose. A deliberate decision was made to redact them. That decision was a mistake. But the fact that a mistake was made does not, without more, render that an abuse. And this is where, to a certain extent, one needs to look at matters purposively and the court needs to draw a conclusion in my submission as to why that was being done. Was that being done to try and avoid the need for pre-action correspondence? Well, in our submission, plainly it wasn't, and I've already taken your ladyship and your lordships to the extract from my instructing solicitor's witness statement where he sets out the number of contact attempts that are made. Was it being done to disadvantage the defendant in some way, or was it simply a mistaken, possibly over-egged concern about the claimant's confidentiality? And in my submission, the judge below was entitled to find and was right to find that insofar as that was a mistaken approach, it was simply a mistake. It was nothing more than that. I think I've already taken you to 229. But when one's seen that early correspondence, it explains why the letter of claim that is sent is redacted. There is also, I don't know that I need to go through all of the various emails that are sent, but there are also email chasers that are sent in which the secure email address is asked for. And one can also see, and this is where I will go back to the witness statement of my instructing solicitor, and this is page 215. It's the repeated phone contacts as well. People from your lawyers calling up to try and establish this secure line of communication. And there is actually some of the call logs were put in evidence. So they're at page 224. So you can see, for example, 19th of February 2019, calling and asking to speak to Sarah Evans, who, as I understand it, was possibly a named director, seeking secure contact details for letter of claim. So none of this is being done due to a desire to maximise cost recovery or to give the defendant the runaround. This is being done, as I say, out of an enhanced concern for the claimant's confidentiality. I accept the point my learned friend makes that no one on the defendant's side or the defendant rather, is not criticised. And there was no challenge to the defendant's assertion that he thought this was a scam. Of course, we don't know how the defendant director responds. But I suppose I'd simply ask the rhetorical question, if he thinks this is a scam, why does he not go on the internet and Google your lawyer's solicitors? He can find out in about 10 seconds that it's a legitimate firm of solicitors. Why equally does he not speak to his insurers? Because he's covered for this sort of liability. He could send this correspondence to them and ask them to deal with it. So it's not exactly as if it's obvious that someone is going to look at this as a scam, because there are various ways in which the authenticity of the solicitors could be supported, or someone could actually pick this up. So we say that is the background, and those were the arguments that were being advanced before. And it's against that backdrop that we turn to consider the grounds of appeal.
Could I just intervene? You said a moment ago that none of this was being done to enhance cost recovery or give the defendant the runaround. Is that the thrust of what you understand now to be the case being advanced against your solicitors?
Well, I suppose it depends what the criticism is. If the criticism is of anonymisation, then I don't understand the criticism in relation to the anonymisation to be that the anonymisation was being done for the purposes of racking up costs or to give the defendant the runaround. I suppose to a certain extent I'm trying to address the broader thrust, which is the whole approach pre-action is adopted due to a desire to enhance cost recovery. But I suppose the point I'm trying to make is, insofar as there is a criticism to be advanced of the pre-action conduct, it is the anonymisation decision, and that decision, if it is to be impugned, is to be impugned as a mistaken decision as opposed to a deliberate decision, a deliberate tactic done to frustrate the opponent or to have some particular cost benefit.
I mean, the anonymisation is something which you were aware of well before the hearing before DJ Nicolle, isn't it?
Yes.
So it might be said that you standing here and drawing inferences from the letters could be undermined by the fact that your solicitors could have easily put in evidence explaining that.
Well, they could have done. I suppose, again, we come back to what end did they understand that those matters were in issue. The only extent to which they've been put in issue is apropos of an argument of prejudice, the defendant's argument, well, had I had more details before, I could have investigated the claim before.
Well, I mean, actually, in the supplemental skeleton argument, 23rd of whatever it was, you do respond in some detail to paragraph 16 of the respondent's notice, which deals with this pre-action correspondence. And following on my Lord's point, I think if you are saying it's legitimate for us to draw inferences from this letter, on one point, is it legitimate, do you say, for us to draw inferences generally from the letter and the way it's framed? Because you've invited us to draw an inference.
Yes.
without
Yeah,
any
no,
evidence.
I can't.
And if as it were, if we're into that territory, is it your case that we are entitled to draw any inferences that we think are legitimate? From
Yes,
the letter in the
I
absence
can't.
of
Well, that's a slightly different question. Is it legitimate for you to draw inferences from the letters, both in support of me and against me? Of course it is. Is it legitimate for you to draw inferences from the absence of evidence? The question, I suppose, then becomes what would be the basis for the inference? And normally, to draw an inference from the absence of something,
Yes.
you would need to establish the basis upon which something should have been provided, which is why the court would need to ask itself the question, to what extent were these matters in issue? To what extent would a solicitor have felt compelled to respond to them? And in my submission, when one looks at the way in which the prejudice argument was put, it is a possibility that a solicitor at first instance could simply have taken the view, well, I don't need to respond to this stuff because it doesn't go to the key issue as effectively before the court at this stage, which is whether or not the claim form is valid.
So page 333 of the paragraph 22 of the your skeleton argument, you say, so paragraph 22, subpara 1, this is not a cable case. This wasn't a case of a party failing to follow the mandatory RTA protocol. No such protocol applied, you say. The claimant attempted to comply with the general PD on pre-action conduct. The defendant may criticise the content, but it cannot get around the fact this was a bona fide attempt to comply with the PD. So you were addressing, I think, head-on your conduct in the context of the protocol world.
Yes, I accept that. Albeit the complaint there, I suppose, was to do with the absence rather than the choice. I suppose I have to accept in one sense, I do take my learned friend's point that arguably the PI pre-action protocol applies in the early period. I suppose what I would pray and aid is the guidance in the protocol itself, which is that what the court is concerned with is not technical compliance with the protocol, it's matters of substance. And the submission we were trying to make below is that there was an attempt in substance to comply, an attempt to engage.
Mm-hmm. I understand. Thank you.
I was going to address the grounds of appeal then. I suppose that the point I would simply make is, just before I leave that point, that there are two questions before the court, or two questions before the court below and two questions before the court now. The first of which is, even if you find that everything that was done entirely wrongly, does that constitute an abuse? And even if it does constitute an abuse, is it an abuse of sufficient seriousness to justify the striking out of the proceedings? And that is why, for example, if the criticism were put, well, the real problem here is that you don't provide a copy of the medical report, or there's no attempt to engage in relation to selection of medical experts, my submission would be, well, the ordinary way in which the court would deal with that would be by appropriate directions and cost sanctions. It would not be the strike out of the entire proceedings. In terms of the grounds of appeal then, which is the fifth head of submissions I had, my primary position, of course, on ground one is that this argument shouldn't be open to the defendant. Can I look, if you're against me on that, just quickly at the cable decision? Because there's some differences in emphasis, I think, between myself and my learned friend I'd just ask you to have in mind. So that's the authorities bundle starting at page 55. So para 42 onwards of the decision in Cable on page 55 sets out the law in relation to abuse. Para 45, the law is summarised as being a claim must be clearly shown to be an abuse before it can be struck out. The striking out of the claim is a draconian remedy and one that should be seen as a last resort. And then when one turns over the page and looks at page 47, you see also the court's reluctance to countenance striking out a claim save as a last resort can be seen in the Alpha Rocks case. And then if I could ask you to read that quotation from the Alpha Rocks case, partly because, again, it sets out the requirement for there to be a clear finding or for it to be, quote, clearly established that there has been an abuse. So we're not concerned with marginal matters. Can I then ask you to turn on to paragraph 55, which is on page 57? Now, I agree with my learned friend's general proposition that non-compliance with pre-action protocols can, of course, constitute an abusive process. There may or may not be a distinction between the RTA protocol, which is more formulaic, and some of the other protocols. But if I could ask you to look at, in particular, it's the final sentence of paragraph 57, where the court says, it seems to me to follow that non-compliance can, in an extreme case, amount to an abusive process. So it's a finding that's open to the court to make, but it will only be in extreme cases. And again, it's got to be a clear finding. The other point that I wanted to make on the approach here is, and a hard copy of this has hopefully reached your ladyship and your lordships, we are agreed between myself and my learned friend that whether there is an abuse is an evaluative judgment, but a gloss is placed on that by the Aldi case, which you should have in hard copy. And I just ask you to read paragraph 16 in your own time. It effectively makes the point that although this is an evaluative exercise, where the exercise has been conducted below by balancing different factors, the appeal court will normally want to see some error in judgment before it will interfere, for obvious reasons, because otherwise the point could be challenged again and again and again.
Sorry, paragraph
16.
16.
16.
Thank you.
And then I think you have my submissions really in terms of why we say the judge was right to find this was an abuse, that PI claims were always advanced, that there was no wrong protocol, that there's no cherry picking going on here, and that insofar as there is a complaint about the anonymisation, like I said, there is a complaint about the anonymisation, but that is a decision that is made as to how to present the claim. It might be it's the wrong decision, but there was still an attempt to comply with the substance of the protocol. And because there is an attempt to comply with the substance of the protocol, that is why the judge was right to find that there was no abuse. The only other point I suppose I would make in relation to ground one is that ground one of itself is not sufficient for the appellate to get home. The appellate would need to get home on grounds 1 and 3. And success on ground 1 does not mean that success on ground 3 would follow. Ground 2, I don't know that I have much to add to the points that were canvassed in oral argument earlier. So if one looks at the judgment between paragraphs 73 and 87, it is clear in my submission that the judge below took everything into account. He was just ultimately not with the defendant on those points. He was not dividing between the continuation of the claim and the pre-action conduct. He looked at matters in the round and expressly rejected my submission that he should not be looking at all of those matters. So far as ground 3 is concerned, ground 3 is the challenge to the judge's discretionary decision that even if he had found there was an abuse, he would not have struck the claim out. Now, in our submission, this is a pure discretionary decision, so it is to be reviewed on AEI and rediffusion grounds. So there is a need, in that sense, to identify that the judge has got it plain wrong, if I can put it that way, as opposed to the slightly lower level of threshold in relation to the assessment of abuse. I've already been through cable and the key points there, but just to re-emphasise, it is recognised in the proceedings that strikeout for abuse is the ultimate sanction. It is the last resort, effectively. And what the defendant needs to show is that the judge was wrong to not consider that this was a case appropriate for the last resort. And in my submission, the fundamental problem the defendant has is the way the defendant tries to get over that threshold is to say this case always needed to be struck out because of the failure to serve in time. And that takes us back to the Quox point, which is, if the case always needed to be struck out because of the failure to serve in time, it's the failure to serve in time that is the cause of the strikeout. It is not the abuse that is the cause of the strikeout. Ergo, Quox does not get off the ground. There is an argument about prejudice that my learned friend advances, and he says the judge doesn't consider prejudice, and we say that the judge considers all matters in the round. But in any event, if one considers the prejudice argument, such as they were below, what was the prejudice the defendant was relying upon? The defendant says, well, because we weren't notified of the claim, we don't get the ability to investigate it because the claimant dies. The first point is the point I've already made, which is, well, that sounds against the claimant more than anyone else, because it's the claimant who then, or rather the deceased, who can no longer give evidence in support of the impact of the claim. So far as the defendant's concerned, it is always able to fully investigate and respond to the claim because that is what it does. And in the core bundle at page 153, you have a long and detailed defence that the defendant provided. And it is apparent from that defence, in particular paragraph 13, which starts on page 156 of the core bundle, that the defendant was able to investigate the circumstances in which this data breach took place and is able to advance a positive case. So there is no prejudice so far as matters on the defendant's side of the table is concerned, because it can still investigate and does investigate. So actually, it's quite the other way round. The third point I'd make on prejudice and why, even if it wasn't considered, it's a bad point, is we would say, and I accept we didn't fully descend into the argument on this below, but ultimately it's the defendant's point, because the defendant keeps on getting these letters, people keep on calling the company, and at no point seemingly does the defendant go on the internet and seek to verify if the firm of solicitors is a legitimate firm of solicitors. At no point does it get its insurer involved. So any prejudice it faces could not have been determinative in these circumstances, particularly when it must have been entirely unforeseen and unforeseeable that the deceased would pass away. So we would say that there is simply no basis upon which this court could properly interfere with the discretionary decision of the judge that this is not a case that would warrant strikeout anyway. I don't know that there's much I can or need to say in relation to the final ground on costs. I think that the key point is this. There was never any challenge to the substance of the order of District Judge Nicolle declining jurisdiction to deal with the claim. The appeal was always about costs and costs only. The challenge to the strikeout order was only a challenge that was mounted because if the strikeout order goes, then necessarily the exception to Quox goes. It was simply another way of getting to the end result, which was avoiding an enforceable cost liability against the claimant. So, to a certain extent, the various limbs of appeal were variations on the same theme. It was always of getting to a position where there was no enforceable costs order or a smaller enforceable costs order against the claimant, and ultimately the claimant was successful in that on one of those grounds. And we say the judge correctly identified what the substance of the dispute was, correctly identified the successful party, and insofar as it said he should have departed from the normal rule to some extent, we say, well, that's a discretionary decision, and it was open to him to say that it wasn't appropriate in the circumstances. Insofar as I need to elaborate that any further, I suppose the key point is probably that I ask you to look at the appellate's notice from the first instance appeal, where it will be seen that there was no challenge, as I say, either to the dismissal of the claim. There's actually no challenge to some costs order being made against the claimant. I accept we sought to reduce the cost order from a cost in the case with cost of the application, effectively because if we were unsuccessful in the Quox challenge, we wanted to reduce the extent of the costs. Except that was unsuccessful, but because we won on the broader point, which was the enforceability.
What is interesting, is this right, looking at the judge's decisions at paragraphs, 94 fines, page 67 of the core bundle, looks at success, levels of success. Then he says, shall I depart then from the appellants being the overall winner, as he puts it, to the conduct? I don't consider there are particular conduct issues relating to the appeal itself. Partial success, offer to settle. Does he consider, if you are right about abuse and all the rest of it, the pre-action protocol conduct, does he consider pre-action protocol conduct in reaching his decision on costs?
I think I'd have to accept that he doesn't, because when one looks at paragraph 100, he uses quite careful language.
He does.
He says, I do not consider there are any particular conduct issues arising in relation to the appeal itself. In my submission, he made a judgment call as to whether or not the pre-action conduct issues are relevant to the appeal, and he decided that it was appropriate to consider the issue of conduct in relation to the appeal and the appeal alone.
Was he right to do that?
That is within the scope of his discretion. In my submission, he was right to do that because the pre-action conduct would be relevant to the costs order made below, i.e. by District Judge Nicolle, who had ordered that the claimants paid the defendant's costs, not simply of the application, but of all of the proceedings. So insofar as that conduct merited a cost sanction, for want of a better description, that had already been encapsulated in District Judge Nicolle's order. And the judge hearing the appeal is then considering conduct between that order having been made and the matters before him. I suppose another way of looking at it might be to say to what extent, and a way of testing the correctness of the judge's decision, to what extent is pre-action conduct relevant to the costs that are incurred on the appeal, because he was only making a decision in relation to the costs incurred on the appeal. Unless it is said that the pre-action conduct is in some way relevant to the costs that are incurred on the appeal, in my submission, the judge adopted the right approach by drawing that distinction between conduct generally and conduct on the appeal. I appreciate I might have gabbled through things slightly this afternoon. If there's any questions, I'm happy to field them.
Thank you very much indeed, Mr.
I do have one question. It's a very small thing. I thought I knew what your grounds of your respondent's notice were because I've read them in your skeleton, but I can't find a document in the bundle in which the grounds appear.
Yes, it was missed out from the bundle and should have been either filed separately or in the updated version.
Thank you.
I think
If you file it separately, I'll find it somewhere.
I've got a hard copy, if that assists.
Thank you.
Mark, anything? No, thank you very much.
Thank
indeed.
you.
Thank you. Yes, Mr. Wade.
Yes, I promised the court some references to the transcript. Could I just deal with the question that my lady asked Mr. Wibberley about whether the judge had been asked whether he would permit fresh evidence to be led in respect of the pre-action conduct correspondence. My lady, paragraph 78, page number 63 of the core bundle.
Thank you.
And if we look at the last two sentences, the appellants knew, that's of course the claimants, that they were being criticised for their pre-action conduct. Permitting this issue, in my judgment, does not necessitate new evidence being led, and if I permit it, I do not consider the hearing below would have been conducted differently with regards to the evidence. And he goes on to say, I do not accept the proposition that the appellants are put at some unfair disadvantage by this because the original application did not seek strikeout for abuse of process, and it was only raised when cost came up. Strikeout for the purposes of cost was dealt with at the appropriate time in my view, at the appropriate point when costs were raised. That doesn't sit consistently with what has been said about the invitation to be permitted. I note that the learned friend made the point of saying to you that the skeleton argument that appears at the back of the supplemental bundle may have been lodged for the purposes of permission to appeal. I note on page 327 that underneath the tram lines it is said that it is for the appeal hearing on the 27th of July. So we have ensured that the appeal hearing skeleton argument was included rather than the permission to appeal skeleton argument. The lady asked the question at the start of Mr. Wibberley's submissions about whether His Honour Judge Owen worked on the basis that the judge below had found that there had been an abusive process and would have struck it out for an abusive process. The page references on that, as I said, that was the judge's understanding, is page number 43 of the core bundle, and if one looks at paragraph 28, he records in a brief further judgment the learned district judge concluded that continuing with the claim after the claim form had been served out of time was an abusive process, and that the proceedings were live until they were struck out, and that there should be a disapplication under quox. And then further on at page...
Give me that reference again, Mr. Waite, I do beg your pardon.
Of course, my lord. It's paragraph 28,
Yep.
page number 43 of the core bundle.
43 of the core bundle. Oh, I see.
Core
the
bundle.
That's it.
The transcript's in the core bundle, so I will be looking at the core bundle unless we move to another document or to another bundle. And then again, it appears at page number 58, core bundle transcript, and it is at paragraph 58, where he says, second sentence, I equally, however, consider that this is strictly unnecessary to strike out a claim where the court declares that it should not exercise its jurisdiction to try the claim, but it's a claim which, once that declaration is made, cannot proceed any further. In a literal sense, the learned judge was right when she said that the proceedings are extant until they're struck out. However, the fact that the proceedings might be extant is, in my judgment, irrelevant. They are proceedings which the court has declared it's not going to further to deal with. And then at paragraph 59, he goes on to say in the second sentence that he could see no reason why, in principle, the order for strikeout should not be made, even if the court had declared that it should not exercise its discretion to try the claim. The proceedings are, as I've already explained, not a nullity. So the strikeout point, as it was challenged in the appeal, as is recorded in his judgment, and even though this is an extempt judgment, he took some time to consider his judgment before delivering it, and it is, of course, an articulate judgment, a detailed judgment, and a lengthy judgment, and this clearly makes the point that I pointed out to this court that that was the basis that he was approaching it on. My Lord, Lord Justice Warby asked me about whether there was any record in the judgment of me taking the point about the pre-action correspondence and the pre-action protocol and so on. And we find that at page number 44, again, we're in the core bundle, and it's at paragraph 32, round about the middle of that fairly lengthy paragraph, where the sentence begins, in relation to ground 4, the respondent said that the appellants did not challenge the assertion at the hearing below, and that the matter should be struck out for an abuse beyond asserting that there was no proceedings extant to strike out after the court declared that it had no jurisdiction. In other words, the only point that the appellants were making is in respect of jurisdiction, in other words. And then he goes on to say, it was said by the respondents, that had the points been raised before the learned judge, she would have had the opportunity to address them. And goes on to say, in any event, the respondent said that the learned judge was entitled to reach this conclusion that there was an abusive process having regard to the pre-action conduct.
Save your voice and read to the end of the paragraph, thank you.
Yeah. And it carries on. So he has recorded that those arguments were made.
But no argument of abuse because of failure to use the personal injury protocol or playing the game by running two horses at the same time.
Well, the personal injury protocol came, that is in this appeal because of the finding that was made by His Honour Judge Owen insofar as saying this was squarely a personal injury claim. And that's why at first instance we were saying if it wasn't a personal injury claim, if it was a claim that would, as they submit, have fallen under the media and communications protocol, then that's the protocol that should have applied, and it didn't comply with it. But the point that we raise in this appeal is that if this is a personal injury claim, and it appears now to be accepted that it is because the replacement skeleton argument says this was a personal injury claim, then the personal injury protocol should have been followed. And
What I was actually looking for was a record of you having made to His Honour Judge Owen the submission that you're making to us, which is that it was a flouting of the protocols. In other words, a deliberate decision not to comply with the protocols. Now, of course, it was said that there was, as a matter of fact, non-compliance and various things were not done that should have been done. I don't think that's an issue. There's a debate about what points were made about non-compliance. But my question was about whether you had advanced the very specific point that it was all deliberate.
Well, the point about it being deliberate arises from the judge's findings, because the judge disagreed with the judge below. The judge below, albeit briefly, criticised the way that the pre-action protocol letters were sent, and accepted the explanation that was given by the director of the defendant company that he thought it was a scam. The argument that there was a mistake did not appear in the claimant's skeleton argument in support of the appeal. It was a finding that the judge made when he gave his judgment. So the fact that no point had been argued on that, my lord, is because that is what we are appealing, because it is a reason that he has given for not finding that there had been an abusive process, and we are saying he was wrong on that. Nobody below argued that the protocol ought to have been followed, or that one that should have been selected over the other, or that it was deliberate. Albeit that the pre-action protocol correspondence was criticised, and if we carry on that same passage, you'll see that he's recorded that the appellants had not complied. This is recording, summarising, and of course this has to be taken as a summary, that the appellants had not complied with the pre-action protocol by sending anonymised pre-action letters, which were meaningless and which made inconsistent factual allegations. So I hope I've answered your lordship's point. The point is that this is something that arose in the judgment, and we're criticising it because there was no basis for him to reach that decision. My lords, you also raised the point, or this is really an answer to what Mr. Wibberley was saying, that His Honour Judge Owen found that the substance of the protocol had been complied with, I've been again through this transcript. That is not the finding that he has made, certainly not an express finding. All that he has said was that those letters were sent in error or mistaken, but no more than that. And as I made the point when I first got onto my feet, that this judge, the judge below, like District Judge Nicolle, did not criticise the defendant, but was not impressed with the claimant's pre-action conduct, but didn't find it abusive. And the last point that I make, and you invited Mr. Wibberley to explain to you certain things which were not, those things were not in evidence, but there is a point that I wanted to correct. The point that he makes, which has not been evidenced at all, was that there was no prejudice to the defendant because the defendant was able to file a defence. The defence that's filed is in response to the particulars of claim, which actually puts some flesh on the bone and provides some factual basis. Up until that particulars of claim had been served, the defendants knew nothing more than what is in those letters about the claim. And so the first opportunity of investigating and providing a response was at the time of the filing of the defence. Unless I can assist any further.
No.
You said this morning, with reference to the correspondence you've just mentioned, that because there was nothing in that correspondence about it being a personal injury claim, it came as a surprise when a personal injury claim was issued and served. Is there evidence of that?
Evidence directly from
Your solicitor or his client? There are two witness statements. There's one from the director of the company, there's one from your solicitor, both of whom saw all the correspondence and no doubt the particulars of claim. I just haven't found their evidence that it came as a surprise to them to learn when they got the claim that there was a personal injury claim being advanced. It may have just been a turn of phrase. I'm not trying to pin you down, I'm just trying to find out what the actual evidential position is.
Well, it may be a turn of phrase. The point that I was making, all of the evidence was before the judge. The correspondence is all there is, and that correspondence, which I took you to, some of those letters which were sent after the medical evidence had been obtained, which still maintained the same as what had been said before. At no stage was personal injury as a claim singularly identified, or some details as to what the personal injury is, or that there is medical evidence that has been obtained.
No, this is in connection with your point, which is obviously a very fair one, that a legal advisor would look at the claim letter to determine what risks his client was running so that he could give, or she could give, appropriate advice. And I was just wondering whether there was evidence to show what I took to be your submission, that until the particulars of claim arrived, or the claim form, it was the defendant and its solicitors were left in ignorance, as a matter of fact, that they were facing a potential personal injury claim.
Yes, the evidence that's come directly from the defendant is, and I'll have to remind myself as to whether there's anything specifically that is said in respect to that, but it's in the supplemental bundle, and it is found at page number 152, and this is the witness statement of Mr. I remind myself
Sullivan.
It was Mr. Sullivan, the director, and what he says is, perhaps if I could just ask you to look at the previous page, at the top. These proceedings arise out of a claim for damages that occurred. The claim is pursued by the personal representatives, and he says at paragraph 7, the first time I discovered the court proceedings had been issued against the
That's a
company.
different point, I think.
Yes, I don't think he was saying, I mean, when one reads the entirety of this, he is not saying that he knew that this was a claim for personal injury. There were some points taken about the formulation of this witness statement, which was, I believe, drafted by Direct Access Counsel for him.
Yeah, well, that's fair enough, but he signed it, and there's no one's cast aspersions on...
Yes, so he's not, yes, but I don't think he has said that he was aware that there was a claim for personal injury. How could he be? Because there was no claim other than what is said in the correspondence. And as my lady's already pointed out, there's an interesting choice of words, however, that they reserve the right to, or however they intend to bring a claim for personal injury. And that's the sum total of it. Nothing more has been said or communicated.
Thank you.
Well, thank you both very much indeed. Thank you for fielding our questions and completing in the allotted time. Mr. Waite, you have some work, or those sitting behind you still have some work to do in terms of an application to be issued today. If you could make sure that that is directed to this court.
Yes.
Once it's been issued. We will obviously be reserving our judgments and distributing them under embargo in the normal way in due course. Grammatical corrections only, please. Please endeavour to agree any consequential matters arising. But thank you all. Thank you to those sitting behind you as well for their assistance.
Thank you.
That concludes the hearing.
My lady, before the court rises, just as a matter of form, we don't want to find ourselves having to come back over the application. We were simply proposing to insert in the N244 form, which asks for the reason as ordered by the Court of Appeal. So it's going to be an application to add the insurers
Yes, as directed.
As directed.
By application to, join as an appellant, be joined to the proceedings as a second appellant.
It's a second appellant under.
As directed by the Court of Appeal today.
Yeah.
Are you happy with that?
The only thing that troubles me slightly is that you're making the application because you want to,
Not because we've
not
done
because we've told you to. We've told you that if you want to do what you want to do, you need to make the application.
Yes.
Well, it does matter.
It does. It does. Well,
But we have made the order.
yes. Otherwise, you would have said, "Well, we couldn't hear from you anyway," having spent a day listening to me. So,
Yes.
yeah.
All right. Thank you all very much indeed.
All right, I think